It was passed in all of them, but I'm assuming it's in 981.
ठीक है, ये जरा अगर आप पढ़ दें, if you don't mind.
My lord. This is order dated 11th of December 2023.
981 में page 106 पे. जी.
I'm reading the order now, the last order. These appeals pertain to the disqualification of candidates who wanted to contest elections. In civil appeals number 981 and 985 of 2018, the parties are the same. One appeal is with regard to a provincial assembly seat and the other to a national assembly seat. In civil appeal number 984 of 2018, the parties are different, but the issue is the same. The general elections of 2008 required candidates to have a minimum graduation qualification. Some candidates made misdeclarations in their requisite nomination papers. Some produced degrees from unrecognized institutions, and others faked degrees to show eligibility of their participation in the general elections. This court had disqualified all such candidates, and some also faced criminal prosecution. The respondent number 1 in civil appeals number 981 and 985 of 2018 was convicted for a period of 2 years, and we are informed that his appeal against conviction is pending before the Multan bench of the Lahore High Court. However, for the person who purportedly produced a fake degree in civil appeal number 984 of 2018, there was no criminal prosecution. In view of the fact that a criminal appeal is pending adjudication before the Lahore High Court, we steered clear of this aspect and only concern ourselves with the question of disqualification of candidates. 2. The Learned Counsel for the appellant states that disqualification is for life by relying on the decision in the case of Samiullah Baloch versus Abdul Karim Nashirwani, PLD 2018, Supreme Court 405, which held that when Article 62(1)(f) of the Constitution of the Islamic Republic of Pakistan is retracted, the disqualification is for life. However, the Learned Counsel for the respondent in civil appeal number 981 and 985 of 2018 disputes this and states that the period of disqualification is for 5 years as per section 232(2) of the Elections Act 2017, which provision was enacted through the Elections Amendment Act 2023, promulgated on 26 June 2023. The Learned Additional Attorney General also relies on the said statutory provision reproduced hereunder. 232(2). Notwithstanding anything contained in any other provisions of this Act and other law for the time being in force and judgment, order or decree of any court, including the Supreme Court and a High Court, the disqualification of a person to be elected, chosen or to remain as a member of the Parliament, Majlis-e-Shura Parliament or a Provincial Assembly under paragraph F of clause 1 of Article 62 of the Constitution shall be for a period not exceeding 5 years from the declaration by the Court of Law in that regard, and such declaration shall be subject to the due process of law. 3. We inquired from the Learned Counsel whether Section 232(2) of the Elections Act 2017 has been challenged, and they said that they are not aware of a challenge thereto. However, the Learned Counsel are unanimous in stating that unless there is a clear pronouncement by this court on the matter, the returning officers in the forthcoming general elections may wonder whether to apply Section 232(2) of the Elections Act 2017 or the said judgment of this court, which may create needless confusion in the elections and shall not be conducive to democracy. There is also the likelihood of election tribunals and courts being inundated with cases arising out of the uncertainty. 4. The Learned AAG points out that the Supreme Court Practice and Procedure Act 2013 requires that where constitutional interpretation is required, a bench of a minimum of 5 judges has to hear it. He further states that the interpretation of a federal law, the Constitution, and applicability of the decision of the Supreme Court is required, which will also impact elections to the provincial assemblies, and as such, requisite notices be issued. Therefore, notice under Order 27A of the Code of Civil Procedure 1908 be issued to the Attorney General for Pakistan and to all the Advocate Generals of the province. Notice be also issued to the Election Commission of Pakistan and public notice be published in a prominent English and Urdu newspaper having wide circulation, as the decision in these appeals may also affect those who are not parties hereto. 5. Concise statements attending to the said constitutional and legal questions without reference to facts and the particulars of individual cases may be filed. It is clarified that the pendency of these appeals and the questions raised herein shall not be used as a pretext to delay the forthcoming general elections scheduled to be held on 8 February 2024. These cases and any others involving the same question be fixed for a hearing in early January 2024 before a bench constituted by the committee under the Act.
Now, please tell us, has Section 232 within bracket 2 of the Elections Act 2017 been challenged by anyone?
No, sir.
Is that correct?
It was challenged in the loud high court. It was challenged in the loud high court.
Where is the order?
I don't have the order, sir.
Hey, let's go by orders. It was challenged, it was decided or not decided?
It was not decided, I think, sir. Because it was challenged. It's maybe
You challenge the act or somebody?
somebody, a lawyer from the lower bar council.
Who?
I exactly don't remember the name, but sir, it was challenged in the lower.
नहीं, we can't go on a conjecture, we have to go on facts.
हमने सर चैलेंज इसको इसलिए नहीं किया.
आप सिर्फ ये नहीं पूछ रहे हैं कि क्यों नहीं किया, हम सिर्फ ये पूछ रहे हैं किसी ने चैलेंज किया है तो बता दे. अच्छा चलें, एक बात तो ये हो गई. अच्छा, दूसरी बात, अब ये एडवोकेट जनरल्स ऑफ द प्रोविंसेस, do they support the attorney general or they have different contention?
Sir, from Shem, we support the attorney general, sir.
And from Khyber Pakhtunkhwa, I also support the contentions of Attorney General, please.
Who does not should just say so? Anybody? आप बलूचिस्तान और आप किधर से? You support the attorney general's contention or not? Huh?
Hello.
Achha, okay. Now, can we just the judgment is dated when of the Supreme Court? Year the 2018 Supreme Court, and so it is before this law was enacted.
31st January
2018.
2018, my lord.
13th April 2018.
Now let's start with the constitutional provision. Attorney General, if you can come back.
My lord, can I make a very small point?
Let's read the constitutional provisions, then we'll come to you.
Because, my lord, in my appeals, there is another issue also, another question of law which needs my lord's
We will come to
decision.
it. We let's just see what the provision was.
Sure.
And we will, don't worry, we will give you an opportunity. Now, can we read the relevant provisions?
My lord.
Article 62.
My lord, Article 62, Clause 1 and Subclause F. I'll begin by reading Clause 1.
The whole article.
G. A person shall not be qualified to be elected or chosen as a member of Majlis-e-Shura Parliament unless A. He is a citizen of Pakistan, B. He is, in the case of the National Assembly, not less than 25 years of age and is enrolled as a voter in any electoral roll in 1. Any part of Pakistan for election to a general seat or a seat reserved for non-Muslims, and 2. Any area in a province from which he seeks membership for election to a seat reserved for women. C. He is, in the case of the Senate, not less than 30 years of age and is enrolled as a voter in any area in a province or, as the case may be, the federal capital from where he seeks membership. D. He is of good character and is not commonly known as one who violates Islamic injunctions. E. He has adequate knowledge of Islamic teachings and practices obligatory duties prescribed by Islam as well as abstains from major sins. F. He is sagacious, righteous, non-profligate, honest, and ameen, there being no declaration to the contrary by a court of law. And G. He has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan. Clause 2. The disqualifications specified in paragraphs D and E shall not apply to a person who is a non-Muslim, but such a person shall have good moral reputation. This is Article 62.
63 padi.
G. Clause 1. A person shall be disqualified from being elected or chosen as and from being a member of the Majlis-e-Shura Parliament if A. He is of unsound mind and has been so declared by a competent court, or B. He is an undischarged insolvent, or C. He ceases to be a citizen of Pakistan or acquires the citizenship of a foreign state, or he holds an office of profit in the service of Pakistan other than an office declared by law not to disqualify its holder, or he is in the service of any statutory body or any body which is owned or controlled by the government or in which the government has a controlling share or interest, or being a citizen of Pakistan by virtue of Section 14B of the Pakistan Citizenship Act 1951, he is for the time being disqualified under any law in force in Azad Jammu and Kashmir from being elected as a member of the Legislative Assembly of Azad Jammu and Kashmir, or he has been convicted by a court of competent jurisdiction for propagating any opinion or acting in any manner prejudicial to the ideology of Pakistan or the sovereignty, integrity or security of Pakistan or the integrity or independence of the judiciary of Pakistan, or which defames or brings into ridicule the judiciary or the armed forces of Pakistan, unless a period of 5 years has elapsed since his release, or he has been, on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release, or I. He has been dismissed from the service of Pakistan or service of a corporation or office set up or controlled by the federal government, provincial government or a local government on the grounds of misconduct unless a period of 5 years has elapsed since his dismissal, or
anyone in this courtroom who wants to canvass the contrary
from the service of Pakistan or service of a corporation or office set up or controlled by the federal government, provincial government or a local government on the grounds of misconduct unless a period of 3 years has elapsed since his removal or compulsory retirement, or he has been in the service of Pakistan or of any statutory body or any body which is owned or controlled by the government or in which the government has a controlling share or interest unless a period of 2 years has elapsed since he ceased to be in such service, or he, whether by himself or by any person or body of persons in trust for him or for his benefit or on his account or as a member of a Hindu undivided family, has any share or interest in a contract, not being a contract between a cooperative society and government, for the supply of goods to or for the execution of any contract or for the performance of any service undertaken by government. Provided that the disqualification under this paragraph shall not apply to a person, 1. Where the share or interest in the contract devolves on him by inheritance.
जरा बात ना करें माइक के सामने लाहौर से आपकी आवाज यहाँ आ रही है शुक्रिया जी
Provided that the disqualification under this paragraph shall not apply to a person, 1. Where the share or interest in the contract devolves on him by inheritance or succession or as a legatee, executor or administrator until the expiration of 6 months after it has so devolved on him. 2. Where the contract has been entered into by or on behalf of a public company as defined in the Companies Ordinance 1984, of which he is a shareholder but is not a director holding an office of profit under the company. Or 3, where he is a member of a Hindu undivided family and the contract has been entered into by any other member of that family in the course of carrying on a separate business in which he has no share or interest. Or explanation. In this article, goods isko skip karke
not disqualification.
G.
So we can come to
M pe chale. G. He holds any office of profit in the service of Pakistan other than the following offices, namely, again, an office which is not whole-time office remunerated either by salary or by fee. 2, the office of Lambardar, whether called by this or any other title. 3, the Qawmi Razakars. 4, any office the holder whereof by virtue of such office is liable to be called up for military training or military service under any law providing for the constitution or raising of a force. Or N, he has obtained a loan for an amount of 2 million rupees or more from any bank, financial institution, cooperative society or cooperative body in his own name or in the name of his spouse or any of his dependents, which remains unpaid for more than 1 year from the due date or has got such loan written off. Or O, he or his spouse or any of his dependents has defaulted in payment of government dues and utility expenses, including telephone, electricity, gas and water charges in excess of 10,000 rupees for over 6 months at the time of filing his nomination papers. Or P, he is for the time being disqualified from being elected or chosen as a member of the Majlis-e-Shura, Parliament or of a provincial assembly under any law for the time being in force. Explanation. For the purposes of this paragraph, law shall not include an ordinance promulgated under Article 89 or Article 128. 2. Then if any question arises whether a member of Majlis-e-Shura Parliament has become disqualified from being a member, the Speaker, or as the case may be, the Chairman shall, unless he decides that no such question has arisen, refer the question to the Election Commission within 30 days. And if he fails to do so within the aforesaid period, it shall be deemed to have been referred to the Election Commission. 3. The Election Commission shall decide the question within 90 days from its receipt or deemed to have been received, and if it is of the opinion that the member has become disqualified, he shall cease to be a member and his seat shall become vacant. And then 63 is disqualification on grounds
How
of
would you
defection.
distinguish between 62 and 63?
My Lord. My Lord, now, of course, 62 is qualification and 63 is disqualification, but both these conditions are applicable at the time of entry, at the entry point, which is to say that when a candidate files his nomination papers for Parliament or Provincial Assembly, must be eligible under both 62 and not ineligible under 63. And subsequently, if once a member gets elected, then again, he must...
No, it doesn't say elected. It says a person shall be disqualified from being elected.
From being elected.
So
Yes,
it's
sir.
pre-election.
G 62, to, as I said,
63.
G63 also, it says from being elected, but
Some Article 3 says if he is a member.
if he is a member, then, and if there is anything, for example, now there could be few instances.
If you just, let's go to 62. Certain things are factual.
That's right, sir.
He is a citizen of Pakistan.
Age.
Either he is or he is not.
G. And the
2
age.
is age of 25 years. I mean, that's also fact. Either
Right.
you are or you're not. There's no debate here.
And then being on the electoral rolls of a province, that is also
Factual.
Factual.
Now we go to C.
G. That's again with relation
Factual.
to the
Now comes the more difficult ones,
D to G.
which are, I imagine, not easy to ascertain. He's of good character.
And which,
Are you of good character, Attorney General? Don't answer that.
no, depends how you see me.
know.
That's what I had to say.
Please don't answer that. Okay. Not suggesting anything.
No, but
I'm just saying.
this actually says it
I'm
all.
just saying your supporters may say excellent character, and your detractors may say
It is
horrible
very
character.
subjective how you see, how you perceive what is a good character. What is good character? So it is.
And
Who will determine it? Who will determine it?
Yes. So that these are also all open-ended.
you know, if you see D, and it goes on to say who not commonly known as one who violates Islamic injunctions.
Yeah.
So here it is, you may be in absolute violation of Islamic injunctions,
But not
if
commonly
it is not known.
Yes.
So, okay, so it's a very strange sort of wording.
That's right.
Then we go to E. He has adequate knowledge of Islamic teachings.
Yeah.
I don't know how many will pass muster in this courtroom. What level of Islamic teachings we are talking about.
Right.
And practices obligatory duties prescribed by Islam as well as abstains from major sins. Okay, now we all pray for forgiveness of our sins. So we are all sinners in that way. He is sagacious, righteous, non-profligate, honest and ameen. There being no declaration to the contrary by a court of law. Now this is tied up with the court of law clause. The court of law, for instance, the cases before us were people not possessing a degree or producing a fake degree or not a recognized degree. So there is some sort of declaration that this was a stipulation. Now there is another thing inbuilt with that the Constitution never provided for a degree.
Yeah.
That's subordinate legislation. The Constitution did not want you to be a graduate. I think that was inserted in 2008
Yeah.
by Musharraf was then the president.
2002, my lord.
2002.
2002.
Okay. So, but it is not one of the prescribed conditionalities either of 62 or 63.
It was perhaps introduced under Clause P, subclause P of subclause 1 of 63. 63(1)P, which permits prescribing additional disqualifications through an
Can
act
we
of parliament.
read it again? P1P क्या है?
He is for the time being disqualified from being elected or chosen as a member of the Majlis-e-Shura, Parliament or of a provincial assembly under any law for the time being in force.
Now, here the word time being has been used twice.
Yeah.
It could have said he is disqualified for being elected. So time being.
Yes.
And it's been used, the word time being has been used twice in this thing. So it assumes it's not a permanent disqualification. I don't know.
That's what the first usage of for the time being actually indicates, what my lord has just observed, that perhaps it is a time-bound disqualification which can be introduced through a statute.
Okay. Now, with regard to the disqualification of, did the law for degrees, the law did not provide a time period disqualification. So the Supreme Court, in the case of Samiullah Baloch, held that since no disqualification period has been prescribed, it will be forever.
So,
For a permanent
so long as the declaration is in the field, the disqualification stays.
And
That's
the
what-
two be resolved now if the judgment of the Supreme Court also stands and the law also stands. That till the law came into effect, that may have been the position, but since the law has now occupied the field of legislation and prescribed a particular period of time, unless we hear a challenge to the law, which there is no challenge to the law, then why should we disregard the law? That's one way of looking at it. And we don't need to touch the judgment at all, because at that time, this aspect of the matter had not been legislated upon either in the Constitution or by law. So then the courts kind of filled in the vacuum and said that it should be lifetime because there is no period of disqualification. So Samiullah Baloch judgment stays intact, but the law has come in place and it is in the nature of a non-obstante clause. That's one reading of it. What do you have to say to that?
So the question would be, can the sub-constitutional legislation control the Constitution?
So that is one, and then the second would be, can there be legislative overruling of a judgment without first removing the basis on which the judgment came out? So,
Now, can we go to the judgment now of the Supreme Court?
my lord,
Relevant provisions, whatever you think are relevant for our reading.
paragraphs, my lord.
We,
Paragraph 35 है.
G35 and
444 page पे.
G. So this is PLD 2018 Supreme Court 405.
ये चार जजमेंट जो
one
पहले
thing
है
is
ना,
very important.
उनका रेफरेंस है पहले इसके अंदर ना, चार जजमेंट हैं, उसके साथ फिर समीउल्लाह है.
जी.
एक इम्तियाज अहमद का केस है, एक अब्दुल गफूर है, एक मोहम्मद खान है और एक अलादीनो भाइयों है. ये चार
Aladino Bhayo, first Aladino Bhayo, and then the review which came out later in 2020, and the court took a somewhat different view.
Mr. Attorney General, to nullify Samiullah Baloch, the amendment would have been in the Constitution.
My lord, that's why
I mean, if you're looking at the basis of the judgment,
Yeah.
the basis of the judgment emanates from the Constitution. So unless the Constitution were to be amended, Samiullah Baloch could not be undone.
So, because Samiullah Baloch is interpreting a constitutional provision, and Samiullah Baloch
कर दिया है
basically
आर्टिकल
holds that the
63(1)(h)
declaration which is
जो हमने
referred
अभी
to in 62(1)(f) has to remain in field till such time the declaration is
उसका
in the
मेरा नंबर है जी
field, the disqualification
CMA नंबर
stands.
8 है my lord.
What my lord has observed
इस पे केस लॉ
carries
my lord
no
मैंने
time
सारा
limit.
जो बनाई है my lord.
There are no time limits as far as my lord the Chief Justice had just gone through, took us through clauses A through G. Now, as far as D, E, F are concerned, they are all without any timeline. Now, the question before your lordship, and it was also argued in Samiullah Baloch. In fact, all the councils before Samiullah Baloch.
If we consider that through Samiullah Baloch the constitution has been amended, then the constitutional amendment is required, as per my understanding.
My lord,
It is interpretation.
my lord, with respect, Samiullah Baloch also read something into the constitution which was not provided. And
Like, what did they read into the...
my lord, while comparing now, while examining 62(1)(f), the court held that so long as the declaration is in the field, this disqualification stands. While at the same time, when they were examining 63(1)(h), which is under 63 and relates to moral turpitude, which includes dishonesty, and there is a 5-year time limit, the court took a different view while examining both, and it said that, because there is a personal price that a person has prepared by going to prison, so therefore 5 years is good enough. But what the court did not, or with respect, overlook was that in both cases, the declarations are there. Now, in 63(1)(h), there is a conviction which stands. It's only that
it's really a question of interpretation, because what's very interesting, speaking for myself, if you look at 63 G, H and I,
Yes.
I mean, most of the heinous crimes, especially against the integrity and sovereignty of the country, and that person can be allowed to contest election. Where there are punishments, he goes through punishments and comes out and contests election. What is a bit odd is that a civil declaration, which is just for some misdemeanor, like misconduct, which doesn't even carry a criminal punishment.
absolutely.
That carries an absolute bar for the rest of the life. That seems to be a bit odd, because if you commit murder, you commit treason, you commit whatever, you can come back and test election. But if you just forget to write something in the form, you would be out forever.
And
so how does one reconcile? So it's a matter of interpretation.
yes, so that is what my respectful submission would be, because in both, in G, H, and also in I, there is an adverse finding against the person, a declaration by a court of law against that person. In those proceedings, those declarations, of course, subsist. He serves the time or whatever punishment provided by law, and then he can come back in after 5 years. Now here, while looking at 62(1)(f), where there is this, the standard of proof is lower compared to those criminal proceedings under 63(1)(h), which is beyond any shadow of doubt, and that declaration has still come out beyond any shadow of doubt. And here is preponderance of evidence, or somewhere between the two, and here the person is out forever.
But before we go into that, could you just explain to us how can any court, a civil court, grant declaration which is in the negative? I mean, how can a court grant a declaration that you're not sagacious? That cannot happen. So how does that work? I mean, I've been always perplexed about this. We can't get a negative declaration from any court. Can a court say that you're not sagacious? Why would that happen? Because no civil proceedings could lead to a negative declaration. It's always positive. So I don't understand how a court will ever give such a declaration. So then most of the courts which have given this declaration are the constitutional courts. So you have...
That's another
degree
question
case.
now.
And in those cases, is the declaration absolutely clear? I mean, does it say that you're not sagacious, or then we infer from the judgment that because you presented a fake degree, as a consequence, we understand that you are not a mean? I mean, let me just go to
yes.
the language of 62(1)(f) to understand what do we mean by declaration.
Declaration, and also what is a court of law, because, and I say this, and my lord has just observed, in Ishaq Hakwani's case in 2015, a 7-member bench actually framed these 4 questions. They left them unanswered for some other case in future, and those questions were that what would be that court which is to give this sort of declaration? What would be the
happened
procedure?
then in that case?
They left it open, sir. These questions were not answered by a 7-member bench. So which court would it be? What procedure would it follow? What would be the standard of proof? And who will have the locus standi? Now these are the questions which are very, very relevant for the purposes of for this declaration by a court of law. And then also whether the courts exercising, let's say, constitutional jurisdiction who cannot record evidence, where witnesses cannot be cross-examined, a person who against whom an allegation has been brought cannot really defend himself as he is able to in a trial, would the declaration coming
So
from
my question,
Constitutional Court suffice for 62(1)?
Mr. Attorney General, the question which has been there for a while now is, first of all, can there be a civil court granting a negative declaration, number one? And number two, the question is that in constitutional proceedings, where there is no evidence being taken, the court has arrived at a decision that a fake degree has been, for example, I don't know what the other cases are, fake degree has been presented by this person, does not necessarily mean that the court is moving further and saying that you are now non-sagacious or whatever. It's simply saying in this particular matter, a false degree was presented. But I don't know of any judgment where they've actually gone ahead and said, then as a consequence, you're a fraud. So I don't know. So is there a declaration actually coming out of the Constitutional Court also? And can they, without taking any evidence, give such a declaration about a person?
My respectful submission is, my lord, that a constitutional court, now mindful that this 7-member bench left these questions open, but then there are two judgments, one in PLD 2015 Supreme Court 265, which is Panama 1, Justice Ijaz Afzal Khan, speaking for majority, said that a court of law for the purposes of 62(1)(f would be a court which can actually record evidence, which is a plenary court of original, revisional, appellate jurisdiction in civil and criminal proceedings. But
without recording evidence, declaration can be given?
Cannot be given.
Yeah.
And then the same in...
But even a negative declaration cannot be given, even if you record evidence.
Right,
I don't
right,
understand
right.
this. So
And then in Aladino Bhaio, the second Aladino Bhaio, the review Aladino Bhaio, they revisited the original judgment which was given in 2013, where under it was held that once a declaration under 62(1)(f is given, it does not go away with the flux of time.
Declaration में तो यही है ना कि person may not file his own case for declaring him Amin.
Yeah.
Somebody has to challenge his character.
That's right.
Then in that case, the declaration will come whether he is Amin, sagacious, righteous or not.
Yeah.
So ये declaration होगा ना, खुद तो जाके नहीं मांग सकता
और
declaration.
दूसरा नेगेटिव एज पर
Somebody will come challenging.
सिर्फ पैटर्निटी पे हो सकता है शायद, एक एक्सेप्शन है 42 में, देयर इज नो अदर एक्सेप्शन.
Section 42 में तो legal character कोई deny करता है तो suit file होता है ना. If somebody is denying his legal character, then he can file the suit under section 42 of the Excessive Back.
What right?
और अगर आप कॉन्स्टिट्यूशन कोर्ट्स के केसेस भी ले लें ना, तो फॉर एग्जांपल somebody has not, for example इलेक्शन ट्राइब्यूनल says that the nomination form में फलां चीज नहीं है, तो मिस डिक्लेरेशन इन्होंने की है. चलिए ये बात तो हो गई, इन्होंने मिस डिक्लेरेशन की. अब इसका क्या मतलब, फिर हम खुद जोड़ते हैं, हम कहते हैं कि क्योंकि मिस डिक्लेरेशन की है इसलिए फिर आप अमीन नहीं है, इसलिए 62(1)(f लग. But the court has not said it. The court is not declaring that you are non-sagacious or not Amin. But the court is simply saying you have filed, there has been a misdeclaration in the form. So, उस पर जरा elaborate करें, how do we actually get, where is the declaration, actual declaration from the court of law?
उसमें कहीं पर वो करेक्शन के भी प्रोविजन है, अब जो नॉमिनेशन पेपर्स हैं.
और ये सो मोटो डिक्लेरेशन है या कोई केस फाइल होने के बाद है ये डिक्लेरेशन?
Now, this is again very interesting because in some judgments in Sher Alam's case, for example, the court says that a writ for quo warranto can be filed, and that obviously comes in constitutional jurisdiction. And in fact, this court can take suo moto notice under 184(3) and gives
quo warranto देखे ना, वो तो Article 199 में it is totally different.
बिल्कुल.
The person has to show under what authority of law he is enjoying the office.
That's right, sir.
वो तो ऑफिस में जाने के बाद है, not prior to.
जी, ऑफिस में जाने के बाद होगा, but as far as that declaration is concerned, question is, can that declaration be given in those proceedings, or for that person somebody has to go to civil court or some court which has the original jurisdiction to try and receive evidence, allow the person against whom an allegation has been brought to cross-examine.
एक चीज जरा देखिए, come back to Article 62.
My lord.
Read G.
He has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan.
Yes. Now, if we read 62(1)(g) on its own with the judgment of Samiullah case, the ban is lifetime ban.
जी
If we read them together.
बट जी हाँ मतलब उसका भी
Now
इसका भी
read
मतलब यही होगा
63(1)(g).
जी
It's the same language ideology of Pakistan.
जी for
And here
propagating
it prescribes a ban for 5 years.
जी or the sovereignty, integrity or security of Pakistan.
No, it's the same 62(1)(g) and 63(1)(g)
That's
are
right.
more or less similarly worded.
That's right.
It is working against integrity or opposed to the ideology of Pakistan.
That's right, sir.
Now, if we apply Sabiullah Baloch to 62(1)(g), it is lifetime ban. And if we apply 63(1)(g), it is 5-year ban. Unless you say 62(1)(g), Sabiullah Baloch is not attracted to 62(1)(g). That could be one argument. So,
It's interesting what my lord has observed because if a person is dishonest और उसके खिलाफ मुकदमा दर्ज हो जाए और उसको सजा हो जाए तो फिर 2 साल काटने के बाद 5 साल बाद वापस आ जाएगा. मुकदमा ना हो और पता नहीं क्या हो और एक डिक्लेरेशन आ जाए तो then he's gone.
if he has been convicted and goes to jail, so his
And come
sins
back.
are expiated, right? And he's okay.
Yeah.
Now, if he is, for instance, acquitted or is not even prosecuted, then he is lifetime banned. So I find it difficult that a court of law which has convicted a person, meaning your guilt was established 100%, you are banned for only 5 years, and if your guilt has not been established, because every criminal case has 2 components, conviction and sentence.
That's right.
You can be convicted and you can be sent on parole, or you can be convicted till the rising of the court, or whatever it is, or maybe not. Say for good conduct, we don't convict you this time, we don't sentence you this time, we just convict you.
That's right.
So that will be a lifetime ban, and the person will say, can you please send me to jail so I can contest elections again after 5 years?
Yeah, sentence
I would
me
rather
to the
go to-
rising of the court so I can just go back after 5 years.
So see, certain things are very clear. You are a citizen of Pakistan. I mean, I find okay that it's pretty clear. There may be some gray areas where you may be holding 2-3 nationalities or whatever the case is, or you may have given up or whatever. But generally, age is a determinative factor. It's clear. And then we come to D, E, F, and G, which are vague. And they're overlapping as well because it says is of good character. Now, can any human being possibly say this on oath if he's truthful? If he's truthful.
So it appears that as far as D, E, and G is concerned, there's no third-party declaration. You know, who's actually saying that he doesn't have adequate knowledge of Islam? Who's saying that he's said anything against the integrity of the country? So there's no third party, right? So how does the disqualification work? On that election, and then it forgets about it, and then the next election he can contest? I mean, we found out that he doesn't have adequate knowledge of Islam 20 years ago, and he missed the elections that time. Then he's now become a saint, perhaps.
Alim.
An alim. And then what happens? Does the
Hafiz,
declaration-
alim.
So एक तो वो समझ नहीं आ रही, लेकिन फर्क सिर्फ ये है कि F में तो ये है कि एक declaration खड़ी हुई है थर्ड पार्टी की, तो जब तक वो खड़ी हुई है वो चलता रहेगा. That's what Sabiullah Baloch saying. Sabiullah Baloch actually turns on the declaration.
वो हुआ ये कि एक्चुअली 18th अमेंडमेंट में ये जो डिक्लेरेशन बाय कोर्ट ऑफ लॉ लाने का पर्पस तो ये था कि वो रिटर्निंग ऑफिसर्स जो है ना वो डिटरमिन ना करते रहे या इस किस्म का एलिगेशन कोई और रैंडमली ना आकर लगा दे, और ताकि ये जो डी, ई और जी के अंदर जो हो सकता है वो एफ में ना हो. Because perhaps some
लेकिन
easy.
ये आपके मुताबिक
But वो उल्टा हो गया.
how does D, E and G play out actually? I want to ask this question. आज से 10 साल पहले किसी ने इंटेग्रिटी ऑफ पाकिस्तान के बारे में कोई बात स्पीच कर दी, बस खत्म हो गई बात. अब वो इलेक्शन नहीं लड़ सकता.
ये देखिए कुछ लोग होते हैं तो
उन्होंने 5 years कर दिए ना,
वो
जी में जाके
कहते
आगे
हैं
जाके।
यस आई हैव सीन द लाइट.
वो तो कन्विक्शन
अब इस्लाम में भी तौबा की गुंजाइश आखिर मिनट तक है.
Absolutely, sir.
वो कह सकता है जी मुझे, जैसे माय लॉर्ड ने ऑब्जर्व किया कि मुझे इस्लाम के बारे में नहीं पता था, अब मैंने सारे अब लाइफ टाइम बैन उसको कर दिया कि वो फिर शायद हाफिज बन गया हो सकता है, आलिम बन गया हो सकता है, आप और बेहतर और हम सबसे बेहतर कुरान शरीफ समझने लगा हो, और वो लाइफ टाइम बैन में आ गया क्योंकि उसको 20 साल पहले या 10 साल पहले या 5 साल पहले इन चीजों के मुतालिक इल्म नहीं था।
समीउल्लाह बलूच जो है, इट एक्ट्स एज अ गलिटीन। वो कहते हैं कि जब आखिरी अपील में जब आप आएंगे तो बस उसके डिसीजन से पहले तो अगर आप रिपेंटेंस कर लें तो हो सकता है, वरना वंस that happens then there is no repentance।
कहाँ छोड़ा?
नहीं छोड़ा, 184(3) में तो वैसे ही नहीं होता, बट अदरवाइज भी नहीं।
रिपेंटेंस कहाँ लिखा हुआ है
साहब सुनने जरा, जी साहब
समीउल्लाह बलूच
देखें, इसमें असल बात यह है कि डिफरेंस हमने मालूम करना होगा 62 63A में। व्हाट इज द डिफरेंस बिटवीन द टू? एज फार एज आई एम कंसर्न, 62 इज नॉट गिविंग पावर टू डिसाइड अगेंस्ट अ पर्सन। देखिए इसमें तो सिंपल, ये इट इज डिपेंडेंट अपॉन 63। 63 में जो कार्रवाई करेंगे वो दिखाएंगे, 62 में वो कहेंगे यू आर नॉट क्वालिफाइड। वेयर एज डिस्क्वालिफिकेशन इज इन 63। अगर कोई शख्स सपोज कोई काम करता है, कोई गलत काम करता है, तो अगर आप जी और एज को पढ़ लें, जी और एच वो डिटरमाइन करते हैं कि कोर्ट ऑफ लॉ से जब उसको कोई डिक्लेरेशन हो, ये उस डिक्लेरेशन की बात हो रही है, आई थिंक सो जी। आइए इस पे बात करें कि ये 62(1)(f) कहाँ पे पावर देते हैं कि आप इतने टाइम के लिए डिस्क्वालीफाई हो, इतने टाइम के लिए। वो तो सिर्फ ये बताते हैं कोई शख्स पेपर सबमिट हो रहे हैं उससे पहले बता दिए कि ये फ्ला कोर्ट से इसको सजा हुई, लिहाजा पेपर खारिज, दैट्स ऑल, मैटर एंड्स। The authority dealing with this matter have no power to decide the disqualification period of that person। वो disqualification के period तो 63 ने बता दिया, ये सजा जुर्म करोगे तो इतनी सजा होगी, और उस जुर्म की सजा पूरी होने के 2 साल बाद जब आप निकलेंगे तो फिर आप क्वालिफाई होंगे। तो ये आप जो पहला सवाल जो आपसे किया कि डिफरेंस, आप डिफरेंस जब बताएंगे तो खुद ब खुद पता चलेगा व्हाट इज 62 एंड व्हाट इज 63।
So if 62(1)(f) is juxtaposed with 63(1)(h),
H and H both,
H moral turpitude,
H moral turpitude है, because वो उसके साथ dishonesty etc. वो उसके साथ है, moral turpitude being very broad, और वो examine हुआ similar belief, उसको अगर आप सामने रखें तो the consequence then, if they are to be reconciled, then the consequence is only one, which is that the timeline which is provided for the declaration in 63(1)(h) must necessarily apply to the time to the
फर्क ये हो गया ना कि
62(1)(f).
H में अगर conviction हो गई because it attracted an offense and so it led to conviction, then he can come back. But if it was lesser than even a case where it could constitute an offense and so he could not be taken in a criminal case, a simple declaration was given on the civil side, that goes on unlimited. अब यही समझ नहीं आती, because otherwise then we also have to stay away from the concept of reading into the constitution.
But now that you have started reading in 63A, so I was just
that is also a question.
so you must stop from reading furthermore।
Reading in to
Just another aspect, if you can attend to, can you read D
my lord.
again?
He is of good character and is not commonly known as one who violates Islamic injunctions.
Now please read F.
He is sagacious, righteous, non-profligate, honest and ameen, there being no declaration to the contrary by a court of law.
Now, what does this mean? There being no declaration to the contrary by a court of law. In clause D and in clause E and in clause G, these words are not mentioned.
That's right.
So either you say clause D, E and G are redundant, they're meaningless clauses, because the words there being no declaration, either the same wording should have been followed. And I can't, at least I cannot understand the difference between good character and sagacious. I mean, good character is something different from sagacious. Is good character different from being righteous?
Righteous,
non-profligate. What does that even mean? What does non-profligate mean? What does it mean?
Who doesn't spend wastefully.
Israf.
Yeah.
So good character.
Yeah.
So if you are doing wuzu and wasting water, you become a profligate. Because there's a hadith of the Prophet.
That's right.
Do not waste water, and even if you're standing next to a flowing river. So then he's a profligate. So, and then we go honest. Good character, every good character person is an honest person, I would imagine. And Ameen. I mean, these are words which a Muslim would never even dare utter in deference to the Holy Prophet, that only he is and none of us are. I mean, that is humility and abject humility. You will never say that. Otherwise, why would you seek forgiveness for whenever someone dies? Please forgive his sins. Do we ever say he's entitled to Jannat and Allah Ta'ala grant him Jannat? He never committed a sin. We don't even pray that for ourselves. No honest person will say any of these things, that he's sagacious, righteous, non-profligate. Even the greatest saints in Islam were scared when they were dying, that they were scared of death because they were apprehensive of what may they be meeting in the hereafter. So I don't know, is this generally a wish list kind of situation as opposed to because otherwise everybody can, if I was filing a nomination paper and if someone says he's not of good character, I would not even challenge it. I said, I'm sure I've done something wrong in my life. Maybe I've done it wrong yesterday, so I don't know. So if you're honest and you say, right, this person is right, I am not sagacious, righteous, non-profligate, honest. I do not switch off the lights when I go out of a room. I waste electricity. I waste human resources which the Almighty provides. So where does it end then? I can bring any case into disqualify someone, and I want to save someone, I can also do the same thing.
That's why.
Should such power vest in judges who are themselves humans?
That's why
They want a greater test for parliamentarians than they have for themselves. Does this language find mention in the oath of office of a judge? That I'm not profligate? Does it mention in the recommendations of a judge? All it says you have to be 45 years of age, practicing law for 10 years.
It could be
so we have a lower standard than parliamentarians. Why is this language then not reflected there as well? Let's accuse ourselves before we accuse anybody else what they are or what they are not. So either we have a much lesser test, we can't, at least I would be very scared to meet this test, terrified to meet this test. So either we don't have a similar test, so we have to read the Constitution as a living whole, and where the Constitution has brought down the acts, it clearly says 2 years, 5 years, 3 years, 2 years, or it's factual, you're not a citizen, fine, that's very clear. There is no punishment here, but you're out. So without a punishment, you're out. There's no punishment. So, but suppose a person is a citizen of Pakistan, not a Pakistani citizen, but becomes a citizen of Pakistan later. Would he stand disqualified for life? Suppose he filed a nomination paper and he had another nationality or whatever, and he got disqualified. Is it disqualification for life? And then subsequently he said, okay, I've surrendered my US nationality and now I want to contest. So I don't know, we have to read it in a way that is meaningful. And we must bear in mind the conditionalities that were imposed to exclude people from this. I mean, the degree situation. Thankfully, it wasn't there when the Qaid was around, because he would have been disqualified.
That's right.
He wasn't a graduate.
amendment कब हुई? ये amendment
2002 की 8 की
2002 में.
किसने की amendment?
My lord, this is presidential order.
क्या वो president खुद इन पे उतर सकता था, इन तमाम requirement पूरी कर सकता?
But ये general military general ज़ियाउल हक
नहीं होते, बाद में डिग्रीज करते हैं. शुरू में नहीं होता.
Non-elected members अगर amendment करेंगे तो यही होगा.
Mr. Attorney General, the question is that while we're looking at D, E and G, which to my mind appears to be a guideline for the voters, the actual gatekeepers, and they might keep this in mind when they're voting because nobody can execute them and put anybody behind anything. So D, E and G to sir guideline ho sakti hai voters ke liye, and that's never been agitated. The $1 million question is, how do we look at the line, no declaration to the contrary by a court of law? What do we do with this? I mean, this is in the Constitution.
If I may,
I think my lords have raised the questions. Can we read the law on declarations? What is the law on declarations? Section 42 of the
Section 42 of the Special Relief Act.
I would imagine, is that the only declaration that has been indicated here?
There's no other declaration. और तो कोई है नहीं.
कोई और law होता है declarations का? Specific Relief Act.
Only Special Relief Act, Section 42. लीगल कैरेक्टर के ऊपर जो है ना वो दैट इज द ओनली लॉ.
Declaratory suits are filed under 62(1)(f).
हो नहीं
Section 42.
कॉन्स्टिट्यूशन में रहा ये तो
इन्होंने कर दिया ना, बट अगर कोई चैलेंज करेगा तो वो तो 42 में ही करेगा ना. नेगेटिव डिक्लेरेशन.
इस negative declaration concept है ना, positive declaration is not the negative declaration. We have held in paternity cases that you cannot do negative declarations.
paternity can
किया ना negative positive.
नेगेटिव कर सकते हैं paternity.
नहीं negative positive हाँ. नेगेटिव नहीं हो सकता है क्या?
Person regularly character right of any property.
दे देना इनको स्पेसिफिक रिलीफ एक्ट सर. आप अटर्नी जनरल को दे देना,
कह सकता हूँ कि हम ऑनेस्ट,
यही दे देना प्लीज.
ये मैं दावा फाइल कर सकता हूँ कि झूठा नहीं, मैं ऑनेस्ट.
Yes. Ji.
So that's it.
Ji, sir. I have it before me. Mr. Jilani's iPad is very helpful. Discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. Bar to such declaration, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so.
By the court, to what is understood by court? A civil court
Yes.
under section 9, or is it a constitutional court?
Oh, this is it's a civil court where evidence can be led, witnesses can be examined, where a burden of proof is discharged, and then there is an opportunity of rebuttal.
Suppose in a case where I've done so even, we observe hearing a civil petition for leave to appeal or a appeal that the appellant had dishonestly filed a suit. Suppose we hold that, and we've held so, and impose costs on him. Will that constitute a declaration of a court of law in terms of Article 62(1)(f)?
My respectful submission is no, sir.
Why?
Because you are not a court where that particular issue is actually conclusively determined through a trial.
So we could observe in other cases. We could say in a criminal case that I don't believe this witness is a liar. And that witness will then be struck by 62(1)(f) because it's a declaration of a court of law. In a judgment in a criminal case, he was not an accused there, but he was a witness. And the court says, I don't trust this witness. I found him to lie.
Yeah. My lord,
so it's, then you can bring out every case. We may make an observation against a lawyer. He misled the court, for instance. Sometimes we do that.
My lord,
regretfully. And then if a lawyer contests election, the person will say, you have held that he misled the court. He is, of course, how can you allow him now to contest an election? He's banned for life.
My lord, now...
जी साहब एक चीज और देख लीजिए, डिक्लेरेटरी जजमेंट्स का जो सुप्रीम कोर्ट के लिए प्रोवाइडेड है ना, वो आर्टिकल 184 सब आर्टिकल 1 में वो डिक्लेरेटरी जजमेंट्स हैं सूबे और वफाक के दरमियान जो झगड़े होते हैं ना, उसमें लिखा हुआ है कि सुप्रीम कोर्ट शैल प्रोनाउंस डिक्लेरेटरी जजमेंट. उसके अलावा के डिक्लेरेटरी जजमेंट 184 और 185 में लिखा हुआ है.
No, 184.3 is not mere declaration. I mean, 184.3, the court goes on to conduct...
शिजाज शौकत साहब यहाँ बैठे हैं जो सिविल कोर्ट के माहिर हैं, तो आप बताइए ना ये वाली डिक्लेरेशन कैसे होगी?
दो चीजें ऐड कर दूं.
बता दें.
आप सपोर्ट कर रहे हैं लॉ को या अपोज कर रहे हैं लॉ?
But I'm supporting the law.
The law.
I'm against.
We want to hear from those who are opposing the law.
There's none.
So then
there is somebody who said yes.
Then hear about.
I am opposing this.
So, yeah, I think in the course of proceedings...
Let's hear.
The challenge.
I just want to understand how the opposition is.
That's right.
जी बताइए.
My lord.
आप अपोज कर रहे हैं तो पहले ये बताइए कि इसको चैलेंज किया है.
मैं लॉ को इस बारे में अपोज कर रहा हूँ.
नहीं, पहले बताइए कि अगर है तो हाई कोर्ट में चैलेंज किया वायरिस को इसकी आपने?
मालूम मैंने तो चैलेंज नहीं किया।
फिर अब क्या अपोज करेंगे आप?
गुजारिश ये मालूम क्योंकि समीउल्लाह बलोच केस अगर मौजूद है जो कि कॉन्स्टिट्यूशन कर रहा है,
माइक अपने सामने।
तो इसीलिए तो आपसे पूछा ना, समीउल्लाह बलोच है, उसके बाद आप समझते हैं कि लॉ गलत अमेंड हुआ है, 232 गलत आ गया है, तो वेदर यू हैव चैलेंज द वायरिस इन द हाई कोर्ट और नॉट?
That can be challenged before this proceeding, my lord, because that question is just alive before the Honorable, and the same notice has been issued on that question. And in this proceeding, the Honorable Court has every authority to declare the law which has been passed in violating the provision of the Constitution or whereby.
But अभी उस्मान आपने कहा था कि are you supporting live disqualification or?
I'm
सर मैंने कहा था कि
नहीं उस्मान ने क्या कहा था?
मैंने ये कहा है मालूम कि जब तक समीउल्लाह बलोच मौजूद है ये लॉ नहीं आ सकता, ये लॉ अल्ट्रा वाइड।
मेन केस में आपकी क्या है कि डिस्क्वालिफिकेशन लाइफ को आप सपोर्ट करते हैं या नहीं?
मैं डिस्क्वालिफिकेशन को असिस्ट मैं इस पॉइंट पे करना चाहता हूं कि रीविजिट हो सकता है कानून, लेकिन वो इन कंडीशंस के साथ रीविजिट हो सकता है। वो
आप एक देखें, वजाहत से बात कीजिए ना, गोल शोल बातें ना कीजिए ना। आप लाइव डिस्क्वालिफिकेशन के फेवर में या खिलाफ हैं? सीधी बात
मैं लाइव डिस्क्वालिफिकेशन की फेवर में उस हद तक हूं कि अगर समीउल्लाह बलोच प्रवेल करता है।
आपसे सीधी बात पूछे, हम ये क्या सवाल जवाब दे रहे हैं आप?
नहीं, either you support the principle or
लॉ को सपोर्ट मैं इसलिए नहीं कर सकता कि लॉ अगेंस्ट द जजमेंट ऑफ द सुप्रीम कोर्ट है।
अगेंस्ट द जजमेंट है,
इंटरप्रिटेशन रीइंटरप्रेट हो सकती है प्रोविजन।
सुप्रीम कोर्ट का जजमेंट जब तक था उसके बाद पार्लियामेंट ने लॉ अमेंड किया। अगर आप ये कह रहे हैं इसका मतलब है कि सुप्रीम कोर्ट के जजमेंट के बाद पार्लियामेंट लॉ नहीं बना सकती।
लॉ बना सकती है स्टैट्यूटरी इंटरप्रिटेशन के बारे में, जहां स्टैट्यूट इंटरप्रेट हुआ।
चलिए लॉ का तो ठीक हो गया, बट आर यू सेइंग दैट द प्रिंसिपल सेटल्ड इन समीउल्लाह बलोच, you agree with it?
No, that I don't agree. I want to say that there is some conditions for the on the basis of state decisive principle कि कब वो जजमेंट जो है वो रिविजिट हो सकती है और क्या वो कंडीशन।
आप बार बार वही चीज रिपीट ना करें ना, अब आप सीधी बात हमसे कर नहीं रहे हैं। जजमेंट को छोड़ दीजिए 2 मिनट के लिए, लॉ को भी छोड़ दीजिए, हम सिर्फ आपकी राय मालूम करना चाह रहे हैं। आप लाइफ टाइम डिस्क्वालिफिकेशन को 62(1)(f सपोर्ट कर रहे हैं या नहीं कर रहे हैं? कुछ हाँ या ना तो कर रहे हैं।
मैं नहीं सपोर्ट कर रहा, लेकिन
नहीं कर रहे हैं। अच्छा, हम सुनना चाहते हैं कि कौन सपोर्ट कर रहा है। एक सेकंड ठहर जाए, हम लोग सुनेंगे आपकी वक्त पे, कानूनी बात करेंगे तो करिए। आ जाए, बताइए। एक सेकंड, लेट अस हियर मिस्टर समीउल्लाह बलोच, द पर्सन हिमसेल्फ। सनाउल्लाह बलोच।
बिस्मिल्लाहिर्रहमानिर्रहीम। शुक्रिया मोअज़्ज़ज़ साहिबान।
ये आपका ये केस है?
जी सर, ये मेरा ही केस है।
ये तो लिखा है समीउल्लाह बलोच।
Sir, Samiullah Baloch is my brother, and Abdul Karim Nosharawani, I am the aggrieved person because I contested the election against.
तो समीउल्लाह बलोच कहाँ है?
Abdul Karim Nosharawani, sir, he is my brother because the case is mine. So
आप उनके अटर्नी हैं, आप कैसे आप पेश हुए थे क्या?
जी हाँ, मैं पेश हुआ हूँ सर, बिकॉज मैं एग्रीव्ड पार्टी हूँ। जो मैंने 2002 के बाद जब इलेक्शन हुए, मैं उसकी तफसीलात में बात
तफसील ना बता देना, आप बता दें किस ग्राउंड पे आप करना चाहते हैं।
मैं ग्राउंड पे सर, ग्राउंड ये है कि जो कॉन्स्टिट्यूशनल जो प्रिंसिपल्स हैं उसके तहत सुप्रीम जो जुडिशल सुप्रीमेसी है उसको मद्देनजर रखते हुए
ये ऐसी बातें ना करें अदालत में। जुडिशल सुप्रीमेसी क्या चीज होती है?
मैं सर अगर आपकी इजाजत
नहीं, ऐसी बातें ना करें हमसे। कॉन्स्टिट्यूशनल सुप्रीमेसी की बात सुनी थी हमने, अब आप जुडिशियल सुप्रीमेसी का मैंने कॉन्सेप्ट नहीं सुना है
सर। ये जो
नहीं, देखिए कानूनी बात करें ना, ये ऐसी बातें ना करें
सर। ये जो आर्टिकल 62 और 63 है, ये कॉन्स्टिट्यूशन में गुज़िश्ता 50 साल से और बिलखुसूस 18वीं तरमीम के बाद इसमें कुछ तरामीम हुई, लेकिन पर्टिकुलरली 62(1)(f) में तरामीम नहीं की गई। ये टोटल 5 सफ़ात पर मुश्तमिल कॉन्स्टिट्यूशन के अंदर बहुत क्लियरली एंट्री और एग्जिट पॉइंट्स दिए गए हैं हक के नुमाइंदगी के लिए, इख्तियारात के लिए। कहने का मकसद ये है कि सर जब ये 2013 के बाद से जब ये,
अगर आप कह रहे हैं ना 50 साल से ये स्टैट्यूट बुक्स पे है, तो पहले क्यों नहीं कभी कोई डिस्क्वालीफाई हुआ?
मैं इस पे आ रहा हूं सर। बात ये है कि सर ये जो है 2002 के बाद से ज़ेर बहस आया। ये 20 साल से सर सुप्रीम कोर्ट और बलूचिस्तान हाई कोर्ट और दीगर कोर्ट्स में ये तफसील के साथ ये ज़ेर बहस रहा है मौजूद, और इसमें 62 और 63 की बहुत क्लियरली केयरफुली मेटिकुलसली जो है सर इसकी तशरीह की गई है मुख्तलिफ केसेस में।
मेटिकुलसली ऐसे तो ना बातें करें ना आप,
सर मैं
पॉइंट पे आ जाएं।
पॉइंट पे आता हूं। तो सर जब एक कॉन्स्टिट्यूशन के अंदर जब 63 की जब बात की जा रही है कि वहां 5 साल का تعین کیا گیا ہے کیوں 62(1)(f) میں نہیں کیا گیا؟ اس کی بنیادی وجہ یہ ہے سر، جب میں ایز اے ممبر پارلیمنٹ میں جاتا ہوں، جب ڈکلیریشن دیتا ہوں، وہ اوتھ ہے. میں اوتھ میں یہ کہتا ہوں کہ میں شہری ہوں، میں نے BA پاس کیا ہے، میری عمر 25 سال ہے. یہ جب میرے خلاف جس شخص نے کنٹیسٹ کیا تھا، جب میں نے اس کو کنٹیسٹ کیا کورٹ میں، اس کی عمر 24 سال تھی. الیکشن میں کیونکہ اس کے پاس والد کے پاس BA کی کوالیفیکیشن نہیں تھی، تو اس کا کیا ہوا کہ اس میں 5-6 مس ریپرزنٹیشنز کی، اس میں فراڈری کی، اور جو ڈگری ہے.
فیکٹس پہ نہ جائیں نا، اب یہ بتائیں ڈیلی بتا دیں
اس جگہ ہی سوال ہے آپ سے. آپ یہ کہہ رہے ہیں نا کہ یہ جو ڈیکلیریشن جو ہمیں سمجھ نہیں آ رہی سچویشن کی، وہ یہ ہے کہ میکسیمم جھوٹ بولا نا اس نے، فارم میں جھوٹ بول دیا، مس ڈیکلیریشن کر. تو جھوٹ کی سزا یہ ہے کہ وہ ساری عمر کے لیے الیکشن پروسیس سے آؤٹ ہو گیا. یہ لکھا ہوا ہے آئین. دوسری طرف ہم پڑھتے ہیں تو اگر قتل بھی کر دیا، ٹریزن بھی کر دیا، تو پھر بھی کچھ ٹائم گزرے گا تو واپس آ سکتا ہے. یہ بات ریکنسائل نہیں ہو رہی سر. یہ جو کیس آپ کا سمیع اللہ بلوچ آپ کے سامنے،
آپ اپنا بتائیں.
میں اپنا بتا رہا ہوں سر.
میں آپ کو آپ کیس کو 1 منٹ رہنے دیں، آپ اپنا ویو بتائیں.
میرا ویو یہ ہے سر
بینگ اے پولیٹیشین، آپ بتائیں
کہ 63 کے بعد جب کسی شخص کو سزا ہوتا ہے تو وہ ایک اسٹیگما ہے، اس کے ماتھے پہ ایک داغ لگ جاتا ہے. وہ 2 سے 4 سال قید کا گزارتا ہے. پورے معاشرے میں اس کی فیملی سفر کرتی ہے، فائنینشیل سفر کرتا ہے، مورلی سفر کرتا ہے، اس کی جاری سوسائٹی میں اس کی اہمیت اور حیثیت کم ہو جاتی ہے. اس کے بعد جب وہ نکلتا ہے تو اس کے بعد اجازت ہے کہ 5 سال کے بعد وہ جائے، اگر اس کے پاس گنجائش ہے وہ ہم کے پاس جائے. لیکن اس میں سر جب آپ انٹری پوائنٹ پہ ہی جھوٹ بولتے ہیں، جب آپ داخلے کے وقت
نہیں، جیسے آپ نے کہا، دیکھیں ایک پوائنٹ لیتے ہیں، 24 سال کا تھا، آپ نے کہا کہ اس وقت وہ 25 سال کا نہیں تھا. 24 سال کا صرف ایک ہی پوائنٹ ہوتا، اس کے ڈیکلیریشن پہ آپ نے اس کو چیلنج کر دیا، وہ پروو ہو گیا کہ 24 سال کا ہے. آپ کی رائے میں وہ فار لائف ڈسکوالیفائی ہو جائے گا، پھر وہ الیکشن کنٹیسٹ نہیں کر سکتا. Is it your point?
With your honorable permission, sir, اب وجہ کیا ہوئی اس وقت؟
پہلے
یہ میری وجہ،
یہی پوائنٹ ہے آپ
سر. میری یہ پوائنٹ اس وقت اس لیے سنی جب نہیں گئی، وہ شخص داخل ہو گیا، اس نے وہ چیک بیریئر کراس کر لیا، وہ جھوٹ کے باوجود وہ بلوچستان میں وزیر داخلہ بنا، جو ابھی سے پہلے کیس.
پھر ذاتیات پہ نہ جائیے.
نہیں سر،
ہم ذاتیات کو چھوڑ دیجئے، ہم آئینی نقطے کی بات کر رہے ہیں. ہو سکتا ہے بہت برا آدمی ہے، ہم اس میں نہیں جانا چاہتے، تو آپ ذاتیات کو چھوڑ دیجئے، آئین کی بات کریں. آپ پارلیمنٹیرین ہیں نا، ہم ذاتیات پہ بہت سکتا ہے اچھا آدمی برا آدمی، وہ ہمارے سامنے بحث نہیں ہم نے کریں گے، کیونکہ ہم ایک جنرل پرنسپل تعین کرنا چاہ رہے ہیں.
ثناء اللہ بلوچ صاحب، دیکھیں میں آپ کو بتا رہا ہوں جو ہمارے لیے کمپیریزن میں پرابلم آ رہی ہے نا. ایک طرف 63A میں آپ جتنا مرضی کرائم کر دیں، آپ کچھ عرصہ سزا کاٹیں، 5 سال گزاریں تو واپس آ جائیں. ہمیں یہ پرابلم ہو رہی ہے کہ سول ڈیکلیریشن میں سزا نہیں ہے، کوئی سزا تو اس نے نہیں کاٹی، سوائے یہ سزا اس نے کاٹی کہ وہ والا الیکشن مس ہو گیا اس کا. اگلے الیکشن میں تو وہ آ سکے نا. اب یہ کہنا کہ اگلے الیکشن میں بھی نہیں آئے گا، کبھی بھی نہیں آئے گا، یہ ہمیں سمجھ نہیں آ رہی کہ سول اس نے جھوٹ بولا، جھوٹ کی سزا آپ نے دی کہ تم اس نامینیشن پیپر ریجیکٹ ہو گئے تمہارے، تم نے الیکشن نہیں لڑا، سزا مل گئی نا. جو کرمنل سائڈ پہ اس کو ویسے سزا مل رہی، سول سائڈ پہ یہ سزا ہو گئی. اب آگے چلے نا. اب وہ کیا اس نے جو ایک جھوٹ بول دیا، مس ڈیکلیریشن کر دی، اب وہ ساری عمر کیسے. دوسری طرف پھر تو ہونا آئین میں ہر جگہ لمیٹیشن ہے، ٹائم کی سٹوری ہے ہر جگہ، تو پھر اس جگہ بھی تو کچھ ہونی چاہیے نا.
میں اس حق میں ہوں کہ 232 ابھی جو جون
میں اس حق کی بات چھوڑ دیں نا. اگر دیکھیں، اچھا ایکچولی آئی ایم اسپاٹنگ از دیٹ مختوم علی خان. Can we request you to, since Mr. Makhdoom Ali Khan has written on the Constitution, I don't know if he's involved in any case before us. Are you in these matters? Huh?
Yes.
Which case are you in?
I have filed a CMA 6 of 2024.
For whom? In favor of disqualification or lifetime or not?
My lord, not in favor.
But you're not in. Why? Who have you filed it for?
For Mr. Jahangir Khan Tareen, my lord.
Okay. Now, one thing which nobody has attended to yet, at least one way of interpreting the Constitution is what the original Constitution said. And this Constitution has been, I don't know what's the correct word, changed or ravaged from time to time, what you want to use it. Can we read the original Constitution as it was enacted in 1973?
My lord.
And see what the Constitution then said.
My Lord, I will read that provision to your Lordship. That
Would you like to do it, or shall we ask the Attorney General to do so?
as your Lordship pleases, the history is.
No, we were thinking of appointing you as amicus, but you are representing a party. So, anyways, let's.
As your Lordship pleases.
नहीं पढ़ें 62. Do you have the original Constitution?
Yes, my Lord, I have, and the history is traced in Samiullah Baloch.
No, we want to read the actual text.
The text is there.
85.
ये दे दें इनको, वो दे दें इनको.
Yeah, we have it, my lord.
Qualifications for membership of Parliament.
Can you come to one or the other Mike?
My
For the benefit of.
My Lord, Article 62, there used to be only 3 qualifications. One, he is a citizen of Pakistan.
Read the whole article.
My Lord, a person shall not be qualified to be elected or chosen as a member of Parliament unless he is a citizen of Pakistan. B, he's in the case of the National Assembly not less than 25 years of age and is enrolled as a voter in any electoral roll for the election to that assembly. C, he's in the case of the Senate not less than 30 years of age and is enrolled as a voter in any area in a province, or as the case may be, the federal capital or the federally administered tribal areas from where he seeks membership. And D, he possesses such other qualifications as may be prescribed by Act of Parliament.
So these troublesome provisions were not there.
No, my Lord.
When did they come into?
My Lord, by Presidential Order number 14 of 1985, which is also called the Revival of the Constitution Order.
This is General Zia.
General Zia, when the martial law was coming to an end and partyless elections were soon to
Is it ironic that a person who violates the constitution of the country puts in these conditions? I find that a bit troublesome, isn't it?
Yes, he after D.
Was he of good character? If he violates the oath that he took to uphold and protect the Constitution, and he destroys the Constitution, it's very ironic for me that he inserts a good character, knowledge of Islamic teachings. I wonder which knowledge of Islamic teaching mandates judges to be sent home because they don't swear an oath of fealty to the martial law administrator. What is your view on that?
My Lord, these are, with great respect, all these provisions which have been added by the RCO or the Presidential Order 14.
Was he non-profligate?
My Lord, these are matters which I would say.
Yeah, we want your answer on this.
My Lord, these are matters for divine judgment. These are matters for divine judgment.
You mean to say matter of treason is for divine judgment?
My Lord, no. And treason is not an issue. But if we come to treason, then in
martial law is admitted?
Yes. If it comes to an act of treason, then in that particular case.
Do you think he committed treason or not?
My Lord, in your Lordship is talking of 1977.
You're talking about, yes.
Your Lordship will then have to examine it.
We are asking your opinion.
My Lord, I would be bound by the judgment of this honorable
court. We are asking your opinion.
My opinion is different, but the judgment of this honorable
share your opinion with us.
The judgment of this honorable court in Begum Nusrat Bhutto's case takes a different view.
चले आप नहीं बताना चाहते रहने दें फिर.
My Lord, my view.
चले बाकी पढ़ लेते 63. तो ये D तक था. There was no present D, present E, present F, and present G.
Yes, my Lord. The D
and 63 was also pretty succinct.
Yes, it was, my Lord. 63 was also very limited.
कैसे उसमें हम पढ़ लेते हैं यही समझ
ये सारे
नहीं ला सकते ना
My Lord, 63, a person shall be disqualified from being elected or chosen as and from being a member of Parliament if A, he is of unsound mind and has been so declared by a competent court,